Buenos días, buenas tardes, según el lugar donde estén. Bienvenidos a este cuarto día de actividades de la cuarta Conferencia Internacional sobre Acceso a la Asistencia Jurídica en los Sistemas de Justicia Penal. Mi nombre es Nicolás Laino y soy defensor público de la Defensoría General de la República Argentina y miembro de la Junta Directiva de la International Legal Foundation. En el día de hoy debatiremos sobre un tema tan necesario y fundamental en estos días como es el rol de los proveedores de asistencia jurídica en el combate contra el racismo sistémico y la discriminación étnica. Les recuerdo a los participantes que este webinar está siendo grabado y que podría ser compartido en redes sociales. Nuestro asistente de chat copiará en la ventana de chat varios anuncios sobre el desarrollo de este panel y sobre el uso del servicio de traducción simultánea con el que contamos, pero deseo enfatizar que todos los participantes están invitados a utilizar la función de chat y de preguntas y respuestas para presentarse, dejar sus datos, hacer sus comentarios, compartir experiencias y hacer preguntas a los panelistas. En nombre de las instituciones coorganizadoras, les doy las gracias y la bienvenida en el día de hoy. Como les decía hace un momento, la temática de este panel es el combate contra el racismo sistémico y la discriminación étnica en los últimos meses en los Estados Unidos, con actos de brutalidad policial contra personas negras, donde, claro, el caso de George Floyd, muerto por la acción de un agente policial en la ciudad de Minneapolis, ha sido el que tomó más estado público, despertando masivas protestas y manifestaciones de repudio en todo Estados Unidos y el mundo. Pero lamentablemente el caso de Floyd no es ni el primero, ni el único, ni el último de los casos de brutalidad policial discriminatoria, basada en estereotipos latinoamericanos. Conocemos muy bien, ocurren prioritariamente en perjuicio de minorías raciales o étnicas, de personas que pertenecen a pueblos indígenas. Pido disculpas. O en perjuicio de los habitantes de los barrios más pobres y marginalizados de nuestras ciudades. Estos sectores de nuestras sociedades se ven así discriminados por su pertenencia de clase desde el primer contacto con los sistemas de justicia criminal, la selección que realizan las fuerzas policiales y de seguridad. Pero su sufrimiento no acaba allí, sino que son también estos los grupos que se ven desproporcionadamente sobrerepresentados en nuestras prisiones y lugares de detención, sufriendo allí condiciones inhumanas, hacinamiento, tortura y malos tratos. Estos patrones de discriminación étnica y de racismo sistémico en nuestro continente no son nuevos, pero como todos los problemas preexistentes, se han exacerbado, se han hecho más visibles y profundos durante la pandemia de COVID-19. Sobre estas problemáticas expondrán y discutirán nuestros distinguidos panelistas del día de hoy. Les voy a presentar entonces a la primera expositora. Es un honor para mí presentar a la señora Ana Paula Oliveira, nacida y criada en la favela de Manguinhos, en Río de Janeiro, graduada en pedagogía, 9 años de un disparo por la espalda en manos de la policía militar. Ella fundó el movimiento Madres de Manguinhos para luchar por la memoria, la verdad y la justicia, junto con otras madres en una red nacional, asistiendo a familiares de víctimas de violencia estatal en Brasil. Hoy la señora Oliveira expondrá sobre la importancia de la lucha de los movimientos de las favelas y de familiares de víctimas de violencia estatal para la promoción del acceso a la justicia a los habitantes de las comunidades. Ana Paula tiene toda nuestra atención.
Olá, bom dia a todos. Quero agradecer muito o convite, né, esse espaço de fala. Eu sou a mãe do Jonathan, um jovem de 19 anos, que foi assassinado pela polícia, com um tiro nas costas, no ano de 2014, na favela onde nós moramos, que é Manguinhos, né? E eu não conhecia naquele momento em que eu tive meu filho arrancado de mim, eu não sabia de que forma, o que fazer, né? Quais os meios aos quais eu deveria recorrer. E eu fiquei muito perdida, e para mim, naquele momento, foi fundamental o apoio do Fórum Social de Manguinhos. É um movimento que existe em Manguinhos e que luta, né, pela garantia dos direitos das pessoas que têm seus direitos violados. Se não fosse esse apoio do Fórum Social de Manguinhos, eu não sei como teria sido, né? Porque eles facilitaram esse meu acesso à justiça. Muitas vezes, como a maioria dos moradores de favelas, a gente não conhece nossos direitos. Por isso, muitas vezes, a gente não sabe o que fazer na hora que a gente tem esse direito violado. Quando meu filho foi assassinado, o meu cunhado foi até a delegacia, né? E ele relata para a gente que ele teve um bom atendimento. Mas o meu cunhado, ele é uma pessoa branca e ele não morava em Manguinhos, né? Então, assim, muitas vezes as pessoas elas deixam de buscar pelos seus direitos por medo, por falta de informações e também por medo, principalmente de uma delegacia, porque a gente conhece relatos de pessoas que foram à delegacia para fazer uma denúncia, para registrar uma ocorrência e acabaram sendo presas, né? Então, eu queria também falar aqui a importância, né, de se ter um defensor na delegacia que possa garantir, né, que essas pessoas, que têm os seus direitos garantidos, né? E primeiro direito esse é de fazer um registro, né, de ocorrência e que tenha um mínimo de respeito na hora de fazer isso, um mínimo de respeito e dignidade, que isso seja garantido para essas pessoas, né? Eu trago muito esse exemplo, né, do meu cunhado, porque a gente sabe que a maioria das pessoas que moram em favelas são pessoas pobres, negras, e que muitas vezes não sabem dos seus direitos. E é preciso que haja uma facilitação, né, para esse acesso. E aí eu faço também essa pergunta, né, de que forma fazer valer esse direito, né, de se ter um defensor naquele momento, naquela hora. A gente sabe também que a maioria dos casos de homicídios cometidos pela polícia, eles não têm uma investigação, né? Muitas vezes porque o familiar tem esse medo de ir até a delegacia e fazer esse primeiro movimento, que é de fazer um registro. Muitas vezes não tem nem essa informação de que ele deve, né, ir à delegacia para fazer esse registro. A gente sabe que também que a maioria dos casos hoje que chegam até a Defensoria são casos de violações que aconteceram nas favelas, e favelas essas que existem movimentos, tanto de mães e familiares, quanto outros movimentos que buscam garantir os direitos das pessoas que moram ali, que acabam fazendo um trabalho que deveria ser do Estado, né? Que é o trabalho de acolher, né? E é o trabalho de levar as informações a essas pessoas que têm seus direitos violados. Então, é importantíssimo a existência desses movimentos, e é importantíssimo que esses movimentos também tenham uma boa relação com essas instituições de defensoras de direitos humanos, porque acabam fazendo essa ponte, né, entre o morador de favela, que são a maioria que tem seus direitos violados, né? Então, esses movimentos acabam fazendo esse trabalho de fazer essa ponte entre os moradores de favela e as instituições defensoras de direitos humanos, né? A gente sabe que isso faz com que haja eu acho assim, promover, né, o fato de promover essas parcerias faz com que haja uma garantia maior dos direitos, né, das pessoas, principalmente do direito à vida, que é um direito tão fundamental. E a prova de que essa atuação conjunta ela traz resultados a gente teve uma atuação histórica, né, entre movimentos de favelas, familiares de vítimas e também instituições como a Defensoria e outras instituições defensoras de direitos humanos e do acesso à justiça do acesso à justiça e à garantia de direitos que fizeram, né, uma mobilização em prol da DPF, a DPF 635, que é mais conhecida como a DPF das favelas, que no momento de pandemia, onde o aumento das operações policiais e também o aumento no número de homicídios cometidos pela polícia estava acontecendo, a gente, nessa mobilização em conjunta, conseguimos com que essa DPF fosse aprovada, né, num trabalho muito intenso e em conjunto, conseguimos que essa DPF fosse aprovada, que trouxe um grande benefício para as favelas com o fim das operações policiais. E esse fim das operações policiais fez com que houvesse uma diminuição de 73% nos casos de homicídios, né, cometidos pela polícia. Então, a gente vê que realmente essa parceria entre os movimentos de favelas e as instituições defensoras de direitos humanos e que promovem o acesso à justiça traz resultados. E está aí esse resultado histórico para a nossa luta, né? Eu acho que é um pouco disso que eu queria trazer e falar também que é necessário facilitar mais o acesso à informação. Havia um projeto, que, se eu não me engano, era da ouvidoria da Defensoria Pública, que era a Defensoria ir até as favelas para ouvir os moradores. Porque muitas vezes é isso, o morador ele não tem nem o dinheiro da passagem para se locomover pela cidade. Então, esse trabalho era um trabalho muito importante, que se chamava Circuito Favelas por Direitos, né? E era também uma parceria, né, da Defensoria Pública junto com os movimentos de favelas, academia, que acontecia esses encontros, né, nas favelas, a instituição ia até a favela para ouvir esses moradores, que se sentem mais seguros nos seus lugares, né, nos lugares onde moram, do que, às vezes, eles têm coisas que eles falam ali que, de repente, não falariam saindo daquele lugar ali que eles sentem como um lugar mais seguro para ele. Então, eu acho que deveria repensar também um pouco nesse sentido, né? Já que é mais difícil, né, das pessoas violadas irem até essas instituições, que essas instituições pensem em meios de estarem presentes nesses locais onde há grande número de violação de direitos, para que esses direitos possam ser garantidos, né? Eu acho que é um pouco disso que eu queria trazer, né? É isso.
Muchas gracias, Ana Paula. Agradecemos mucho tu exposición. Tus palabras han sido verdaderamente inspiradoras para todos nosotros, y quedándonos con dos ideas muy fuertes de tu exposición, fundamentalmente la importancia que tiene la cuestión de las alianzas, es decir, aliarnos y que los actores y las instituciones públicas, estatales y organizaciones de derechos humanos tengan conexión con los movimientos de los barrios, los movimientos de las favelas, por un lado, y por otro lado, la importancia de la presencia de las defensorías públicas en los barrios, en las favelas, en las villas de emergencia, en los países como Argentina, en los barrios más pobres, en los barrios donde ocurren los mayores abusos. Y esto me parece que son dos ideas muy importantes de tu exposición, y realmente tu testimonio es muy conmovedor y es un verdadero ejemplo de cómo a través de la lucha de los afectados, de las víctimas, se puede dar voz a las víctimas, se las puede visibilizar para denunciar así las violaciones a sus derechos, para concientizar a la sociedad, a los gobiernos, a los poderes políticos, para hacer que los autores de estos actos de abuso policial y de las ejecuciones extrajudiciales, como las que sufrió Jonathan, respondan por los delitos que cometieron. Voy a pasar ahora la palabra a la segunda disertante de este panel. Maya Lisitsina ha liderado el trabajo de Open Society Justice Initiative sobre prevención de la tortura, habiéndose enfocado durante los últimos 10 años en desarrollar estrategias conjuntas para la documentación y el litigio estratégico en materia de tortura con activistas y abogados en Eurasia, Asia y América Latina. Maya trabaja en las oficinas de Open Society en Nueva York y antes trabajó en Human Rights Watch y fue directora fundadora de una ONG de derechos humanos en su país natal, Kirguistán. Maya expondrá sobre un caso de litigio estratégico y de documentación eficaz de la tortura en Brasil, conocido como Sala Roja, referido a torturas en un cuartel del ejército en Río de Janeiro. Maya, tienes la palabra.
Hi everyone, thanks Nicholas. It's not easy to follow Ana Paula, and I would like to offer some reflections on how we can use strategic litigation to prevent, to seek accountability for, reparations for the crimes that she was talking about. I'll focus on torture. As Nicholas said, I would like to offer some thoughts from our joint effort with Defensoria Pública of Rio de Janeiro on so-called Red Room case. Maybe some of you had a chance to look at the video. It's a case from 2018, from the time of military intervention in Rio, when more than 4,000 soldiers with armored vehicles just descended on a number of communities in Rio and arrested 86 people, at least 5 civilians were killed, and at least 3 service members, and many were tortured. Defensoria represented at least 8 of the survivors in the case on drug possession, on the drug-related case. I also would like to offer some reflection, I don't know if you can see from the report, on strategic litigation impacts of strategic litigation, torture in custody. We'll send the link. That we published in 2017, and that it's looked at more than 30 years of litigation of torture in Argentina, in Turkey, in Kenya. And I think in the answer, you know, the torture is so widespread, it's so accepted. Is it even worse, right? Can litigation change something, right? Why we litigate? Does it make the difference, right? Does it change something for the society? And I'm glad to report that we found that it does, but the impacts are very complicated. We define strategic litigation as a legal process that seeks social change beyond individual complainant. We'll not dwell on the definitions here. And how do we tackle the system, right? When we heard about the Red Room, we had a partnership with Defensoria on mutual learning on strategic litigation. The abuses were very severe, including like shooting rubber bullets inside the room. At the same time, we've heard very similar stories in Asia, in Eurasia, and in other places. And I would like to say that often the experience of survivors and families, what UN Convention Against Torture mentions in its definition, that is kind of the standard for many, as severe pain and suffering. It just transcends the continent, the cultures, the legal systems. But the context on who gets tortured, like why, what allows such horrible crimes. It's crimes, right? It's not just abuse of power to be committed by alleged criminals in uniforms, right? As part of the state, to whom we as societies give the right to use force, but like the legal force. And in Brazil, and I'm not well placed to speak about it, but I think a lot of commentators link this to the history of what is called the structural racism. Across all the countries, there is a similarity though. It's a question on who is the other, whom can you dehumanize, whom can you see that it couldn't be you. And that's critical on how we try to litigate these cases and seek accountability for them beyond the individual abuse. We know from our studies that there are many ways how we can litigate torture. Litigators around the world use criminal, civil, constitutional, administrative, disciplinary, habeas corpus, individual and collective complaints, national, transnational, regional. There's always something to be done. We also know from our reports that impact of strategic litigation are never binary. It's never win or lose. It's always more complicated than that. I do not have time to reflect on it in presentation. And another very important learning that we know that the cases that bring impact, the litigation brings impact, it's generally mass litigation. It's generally successful cases that build on each other. It's rarely one paradigmatic case, which Red Room, I would classify as such, that can change everything. We need it to be the beginning, or it's part of a longer process. And legal aid providers are probably the best place for the access for torture survivors. But in many countries in the world, we see that they either don't have resources or mandate or independence to challenge it. Again, torture is a serious crime. But those who are charged with investigating it, like in Red Room case, it's the military who is suspected of perpetrating these abuses, are supposed to investigate themselves. The wall of silence just stands against such investigations. And lawyers whose job normally is to defend people suddenly need to basically go on the side of the accusing, right? And of seeking accountability. Like in Red Room and in many other cases, the first challenge of torture is to document. What was, and I've done that job for like 25 years, and I still was a little bit surprised to see that the first acts of torture happened inside the community. Perpetrators are so sure of their impunity, they don't even hide. Or maybe it is a message, maybe it's meant to be public. And then there's something else about the Red Room case. It's the torture inside the military that reminded of the times of military dictatorship. The tactics and tools that were used during the time, they exist, they're there, and they can be resurrected at any moment. And in many torture cases, how do we document? It's the word of somebody who is generally accused of crime against the word of police or military. Defensoria, in this case, partnered with International Bar Association's Human Rights Institute, who brought international medical experts, and the Forensic Institute of Rio, the EMLA, agreed to do joint evaluations of torture survivors using the international standard known as Istanbul Protocol. What's important here is like doctors can't give you the legal definition of torture, but what they identified in this case is that the injuries and psychological state of the survivors was highly consistent with their stories. And these reports for the first time were submitted to a court, and the court acquitted the defendants. And the court rebuked the military for what in English translation we learned as a hateful practice of torture. And basically said, you know, if you engage in such acts, we just cannot believe your word on everything else, right? You cannot believe your word on evidence and so on. And we know in drug-related cases, it often is just the word of military that is enough in Brazil to convict. It's an extremely important win. It's an extremely important case that hopefully can inspire others. But I would like to say it took a lot of resources, right? It's not very easy to replicate. The survivors are still facing military charges in military trial. They should have never, at the first place, be charged in the military system, and it still haunts them. I don't think we have time to show a piece of the movie, unfortunately, but they speak there about the nightmares, about how that pain doesn't go away, the survivors live with it. We still didn't see reparations in this case. The military, while investigating this torture, have not charged anyone, and we are very skeptical that it might happen. So for this case to truly have an impact, to challenge the status quo of a systemic abuse, a lot needs to be done in addition to already amazing work by Defensoria and other partners. And in closure, I would like just to say that strategic litigation is only effective when it's connected to other efforts, the efforts that Anna Paula was speaking about of social movements. And torture victims are often alone. And unlike victims of many other human rights violations, torture survivors want to move on, right? They want to have their life, like in the movie, they say, I just want my driver's license back and move on with my life. And we need to find as litigators that balance between not letting their courage, because it requires a lot of courage to challenge the system, to go unnoticed, right? We need to use these strategic cases to seek change beyond their own cases. But we also need to understand the survivors need to just move on with their lives. And that balance is something that we are always looking for in torture cases. Thank you.
Muchas gracias a ti, Maya, por tu excelente exposición, que nuevamente nos trae la idea de la importancia de las alianzas, la importancia de esta conexión entre organizaciones de la sociedad civil, organizaciones de derechos humanos, por un lado, y defensorías públicas, instituciones públicas que también luchan por la salvaguarda de los derechos fundamentales. Y el caso de Sala Roja es un gran ejemplo de esto, y obviamente todos los desafíos que tú expones, que se complementan en gran medida con la intervención previa de Ana Paula, nos demuestran, en este caso a través de un gravísimo hecho, también en Río de Janeiro, como el que sufrió también Jonathan, cómo estas inaceptables violaciones a los derechos humanos a través del uso de la tortura se producen prioritariamente sobre las personas más vulnerables de la sociedad. En este caso son jóvenes de familias pobres, detenidos por delitos menores contra la propiedad, o por tenencia o por comercio de pequeñas cantidades de drogas, ¿no? Entonces, me parece que tu exposición ha sido excelente y nos deja reflexionando muchísimo y da lugar también para el debate en el momento que tenemos asignado a ello luego de las exposiciones. Entonces ahora me voy a permitir escuchar o dar la voz a nuestra tercera expositora, y qué bueno que tengamos tantas mujeres en este panel, y voy a presentar a April Fraser Cámara, que es actualmente la jefa de aprendizaje permanente de la National Legal Aid and Defender Association en los Estados Unidos. April es una capacitadora reconocida a nivel nacional en las áreas de liderazgo, equidad racial, diversidad e inclusión y reforma de la justicia criminal. En el pasado, April trabajó como defensora pública comunitaria en el Servicio de Defensa Pública del Distrito de Columbia. Actualmente se desempeña también como jefa de la sección de justicia criminal de la American Bar Association y es una de las cofundadoras de la Black Public Defender Association. April va a exponer acerca del rol de los defensores de raza negra para poner fin al encarcelamiento masivo. La escuchamos con toda nuestra atención, April. Tiene la palabra.
Thank you, Nicholas. And can everyone hear me? And please let me know if I have a delay with my Wi-Fi. First of all, I would like to say thank you for inviting me to join this very important conversation today about the role that race plays, and specifically I'm going to be talking about the criminal legal system in America, but we have a worldwide issue with racism, and I'm happy. And first, I want to say thank you to Anna and Masha, my co-presenters. It's a privilege to be on this panel with you this morning. So I want to talk to you today about the Black Public Defender Association, which is an organization that I am a co-founder of that was created a year and a half ago. We're not quite 2 years old yet. And this organization specifically was created by Black public defenders in the United States who both do this work because it's professional, but it's also personal. So as Anna shared her story about her son and how his life was taken by state-sanctioned violence from the police, for African Americans, that is a very common lived experience for us here in America. So while the country was shocked by the lynching of George Floyd in May, the Black community in America was not. We have loved ones and family members who have been taken at the hands of police, and oftentimes our cries for help are not heard because we may not have the full footage or video. But the experience of terror that was shown in the lynching of George Floyd, unfortunately, is the historical and lived experience of Black people in America. And so the role of the Black Public Defender Association was to bring together and elevate the voice of Black public defenders to be advocates and transformational leaders in the fight for the liberation of our community, but also in the broader fight for criminal legal reform in America. And you can go to the next slide. So I want to share with you all a little bit about the work of the Black Public Defender Association. And my goal today is to show you a model that could perhaps be replicated in your own country, because we believe strongly that the power of people with direct lived experience must be centered around solutions on how we eliminate racism and oppression in the world. And so hopefully you can see from the creation of our organization how you can empower the Black public defenders in your offices or in your country to create an organization that's intentionally focused on the issue of race and racial equity to attempt to undo this. So one thing that I think is very important in the creation of the Black Public Defender Association is this phrase that we say, in our clients, we see our loved ones, but we also see ourselves. So unlike some people who do this work, you may be able to distance yourself from the communities or the lived experiences of people who you are representing. But for Black public defenders, that is not possible. Because when we say we see ourselves, many of us have experienced the police harassment or being pulled over and being afraid for our own lives and whether or not we are going to make it home safely. Many of us have had to experience the loss of loved ones at the hands of police and law enforcement. And it's, as we do this work, it is almost impossible to find a Black public defender who does not currently have a loved one or family member who is directly impacted by the criminal legal system. Either the person is incarcerated or facing criminal charges within the legal system. So one thing that we think is very important in this work is that you center the experts who understand how the law and the institutions are designed to uphold racial and white supremacy in America. And we feel confident that a part of the solution is that Black public defenders have both the lived experience and the legal training and expertise to work side by side with our community to come up with solutions on how we dismantle the racism in the criminal legal system. And one important thing to note is that when we say Black public defenders, we're referring to all advocates and professionals who work on behalf of people who are accused or oppressed by the system. So you can see that we're inclusive of social workers, investigators, client advocates. We have people who are formerly incarcerated themselves who are a part of our association because now they work on behalf of people involved in the legal system. Next slide, please. You can go to the next slide, please. I wanted to share with you a little bit about our vision and our the programming or the work that we do. If you could go back one. So a part of our vision is to do the work both internally within public defender offices, because if your systems of representation are similar to America, if you could go back one slide, please. Thank you. If your systems are similar to America, many people who are involved in the criminal legal system are people of color, but the people who actually represent them in legal aid offices and public defender offices oftentimes are not people of color. So there is a cultural disconnect sometimes between the people who represent people who are facing the criminal legal system and actually the people that's impacted. So a part of our goal is to educate our colleagues about issues of race and cultural competence. Our goal is also to increase the leadership pipeline for Black defenders. We feel strongly that it's important for Black defenders to be leaders in this work, not just trial attorneys and entry-level support staff, but to lead the public defender offices, to be the chief defenders, to be the president and CEO of organizations who lead these conversations. And we also think it's very important for the Black Public Defender Association to shape the narrative about ending mass incarceration and racism in America. And so those are our goals as an organization. And you can go to the next slide, please. One thing that I really want to note, you can see a picture of me on the screen. The leadership of the Black Public Defenders Association, it was founded by 2 Black women. I think that is very important to note, and we celebrate the fact, as we heard from the story from Anna, oftentimes the injustices in our community, Black women and our role as leaders is oftentimes overlooked. But the Black Public Defender Association was founded by 2 Black women. Myself, as a former public defender, but I think it's very important to note, and Patrice also, who is a former public defender, that we saw a need not only to create this organization in order to advance issues of racial equity, but we also saw a need to create this organization in order to provide a safe space for Black defenders who do this work. Because this work is not easy when you do it every day and you see the injustices, and then you come home to your children and your loved ones who are literally at risk of being touched by this system. So one thing that's really important to note is that our goal is to also provide a safe space, which is very necessary for your staff of color, that when we do this work, it impacts us in a different way. And it's important for us to have a space to process it together as Black people, to talk about what it means for us. If you can go to the next slide. And I will say this picture of the person with the microphone is Kenethia Edwards, who is the mother of a person who was killed by the police in Washington, D.C. So I'm just going to end here and just share with you some of the accomplishments that we were able to achieve in 18 months, which I think is really amazing. We've been able to pull together 2 annual conferences, one in person and one this year virtual because of COVID-19. We've also been able to train at various conferences, because a part of our value is to train the broader communities about issues of race within the legal system. And we've been very privileged to be invited to conferences like this to train the broader community about not just the issues of race, but I will be very clear about the issues of anti-Blackness within the legal system in America. And also, we have really raised the visibility within the media in America around the issues of race. We've been cited by several newspapers and media outlets, invited to do interviews and really elevate this issue of race within the broader community. And also, I'm really excited that we have been able to host fellowship programs for Black law students to allow them to work in public defender offices over the summer and be inspired to become Black public defenders. So I think I'll leave it there, but I do, want to leave you all with some quick advice about how important it is to have organizations that are founded and led by Black people and people of color who are most impacted by the issue. Because while it's great for people to, for us to have diverse coalitions of people doing this work, it is important to center the people who are most impacted in the solution and how you dismantle and how you attack the problem. So I would encourage you, if you don't have an association that elevates the voice of Black people in your community or Indigenous people whoever is most impacted by the issues, that you should take the time to explore devoting resources and to allow them, not for you to create the organization, but to give the communities that's most impacted the resources to create these spaces for themselves and to be equal partners and to be experts and serve beside you or even in front of you in leading the conversation about how to dismantle racism in your legal system. So with that, I turn it back over to you, Nicholas.
Muchísimas gracias. Es algo que aquí en la región, en Latinoamérica, en Argentina, en Brasil, siempre nos estamos preguntando y nos estamos planteando entre nosotros, que tiene que ver con la necesidad de que los afectados, quienes son discriminados, incluso las personas privadas de libertad, las personas presas, cuando nosotros los defensores públicos luchamos por sus derechos, tengan la voz y ellos puedan también ser portavoces del reclamo. Y aquí tú lo estás planteando también con la maravillosa y gran experiencia que tiene la asociación que tú has cofundado en los Estados Unidos, la Black Public Defender Association de Estados Unidos, y que las personas precisamente que ven el problema desde cerca, por pertenecer justamente a la raza negra, puedan llegar a estar dentro de las instituciones y de las asociaciones, ser, como tú dices, sus directores, sus presidentes, y poder luchar desde adentro para lograr un verdadero cambio en el sistema y para poder poner fin o acotar al máximo el racismo, pese a las grandes dificultades que históricamente hemos encontrado para ello. Así que realmente agradezco muchísimo tu gran exposición y nos has dejado todos pensando y reflexionando muchísimo sobre la propuesta concreta que acabas de realizar. Así que te agradezco muchísimo. Luego va a haber más lugar para las intervenciones e intercambios con el público, pero ahora quiero pasar la palabra a nuestro último panelista, al único hombre, al único varón de nuestro panel. En este panel de la Conferencia Internacional sobre Acceso a la Asistencia Jurídica en el Sistema de Justicia Penal. Y se trata de nuestro expositor, el doctor Raymond Naraj. Raymond es profesor asociado en la Facultad de Derecho y Seguridad Pública de la Universidad del Sur de Illinois, habiéndose doctorado en la Universidad de Michigan. Pero Raymond es oriundo de Filipinas y él estuvo 7 años detenido en una de las prisiones más sobrepobladas de ese país asiático, acusado de un delito que no había cometido y por el cual fue luego declarado absuelto. Esta experiencia personal lo volcó a estudiar académicamente temas relacionados con la reforma y la mejora de los sistemas de justicia criminal. Actualmente el doctor Naraj implementa el Community Bail Bond Program en Filipinas, dirigido a sacar de las prisiones a los ofensores de más bajo riesgo y apoyar su reintegración a la comunidad como miembros responsables. Raymond, agradecemos tu presencia en esta conferencia y tienes la palabra.
Okay, thank you very much as well, Nick. And if you could please upload my PowerPoint presentation. And this presentation speaks about the discrimination in the Philippine criminal justice system and prospects for improvements. And this is brought about by my experience as one of a former PDL. I was accused of a crime there and I was eventually acquitted. And now I'm working for the improvement of the justice system. So one of the key issues in our criminal justice system is prolonged pre-trial detention. So many detainees stay on average in jail for 529 days and they are still unconvicted. And in my study, 20% of these PDLs, persons deprived of liberty, stay in detention for 5 years or more. And in some cases, I've documented PDLs staying in jail for 15 years, 20 years, and they are still unconvicted. And so this is a big problem, common problem that is affecting our criminal justice system. However, it has more adverse effect when you compare it to the poor and powerless, less educated people. They stay in jail 100 days more compared to the rich and educated. And also there's discrimination on sexes, where women and the LGBT community stay longer than men by an average of 200 days. There's also an ethno-linguistic variations where the minorities stay longer than the Tagalogs and the Visayas by almost 300 days. So that's at least a year more. And finally, and this is the most egregious, is the religious minorities, especially the Muslims, stay in jail longer, twice the average length of stay of the average PDL, especially the Catholics. So the issue here is what's the reason why they stay in detention while undergoing trial? Well, 53% of the detainees have what we call bailable offenses, as much as $2, some $20 to $30, but they could not post that amount of bail. And also, even if they have the money to post bail, the process is so tedious that people could not follow up with the bail process. There are numerous requirements and documents in posting bail and in what we call release on recognizance, where they could bail out through the promise of the other people who could make sure that they attend in prison. So what's the impact of this? As you have seen probably in the newspapers right now, the Philippines has the highest jail and prison congestion in the whole world. Our congestion rate is 350%. And this is way above the national, international norms of 120%. And this must made worse even by our drug war, which was started in 2016. Such that 70% of these detainees are low-level drug users. And now they are staying in jail for 529 days on average. And this was even made worse by the COVID pandemic in 2020. And there are now many people who get afflicted with COVID virus in our very decrepit prisons. And because of this overcrowding, there now emerge what we call coping mechanisms in the jails and prisons, where inmates would be utilized as leaders inside the cells. And sometimes it has good effect, but also it has bad effect, where recidivism and public safety now is a problem. Our recidivism rate in the Philippines is around 40%, and they pose enormous problem with public safety as well. Next slide. So I just want to show you the notion of overcrowding in the Philippines. So this was taken in Quezon City Jail, the same jail where I stayed for 6 years while undergoing pre-trial detention. And in this jail, this was designed for 284 detainees, but at this time it has around 3,500 detainees. So an overcongestion rate of almost 1,000%. And this is very common in the big city jails in Metro Manila. And so many inmates die because of hunger, sickness, and other forms of malpractice in this facility. So if you could turn to next page, please. So given this problem that we have prolonged pretrial detention and they stayed there because they could not post bail and the bail are very small amounts, we developed this community bail bond program. And this is implemented through a foundation called Preso Foundation that had been doing a lot of work in the Philippines since the early 1990s. And we started implementing this community bail bond program during the time of the pandemic. So we started around May 2020. And what do we do here? It's very simple. We simply identify these low-risk, first-time bailable offenders, okay, without history of going back to jail and prison. So they should be first-time offenders, because we realize that almost around 30% of the jail population are first-time offenders. And while they are in jail, we met them there, we established relationships. But because of the pandemic, we could not visit them. So what we do is we visited them through online communications. So we have to donate computers to the jail. So we provided the jail with laptop computers so we could communicate with our clients. Now we interview them and we interview their family members and then realize what's going on in their lives. And if they are first time, they are low risk, they could be reintegrated back to community. And if they have a bail, we post the bail outright. So it's our organization who posts bail, or if it's enormous amount, we file for a motion of recognizance. And it's our organization that guarantees that they will appear back in court. So the bail ranges from 2,000 pesos, which is $40, to 100,000 pesos, which is $2,000. And we raise funds to our community fundraising. It's called crowdfunding. And we also got support from an international organization called the Open Society Foundations. And then upon release, we conduct supervision and monitoring in the community. So we visit them once a month and we call them by phone every week, just to make sure that they attend court hearings, because we want to get our bail money back with successful meetings. And we also refer them for livelihood programs, educational programs, and medical programs, not only for our participants, but to their children, to their loved ones, to their partners as well. And so far, we have now 23 participants released. And just last night, we have released one juvenile, so that makes it 24. 40% of these are women, and all of them are indigent with an average income of $3 per day. Okay? And most of them have high school education or less. So I just want to show you some of the pictures of our participants. On the right is a 21-year-old man. He was charged of theft and his bail is only $20. But he had been staying in jail for almost 2 years. And so we bailed him out and we paid for his cash bail. The picture on the left, the one on the upper portion, is our participant who is 46 years old. And he is being interviewed here in his family by one of our staff. And we try to help his other family needs. And then the other picture below is another participant of ours where we are now trying to help the children go to school because that's one of her major concerns. So these are the people whom we help. They are very poor, they are very less educated, they are powerless, and without our intervention, they could have stayed in detention even much longer. Next slide, please. So what are the key impacts of our innovation? One, we protect the citizens from the harsh application of the law, especially now because of COVID, they would arrest people who would violate the COVID rules, and we bail them out simply because they could not post bail because of this very menial law that are implemented. And we help in reducing jail overcrowding, okay, in these facilities. And we shield the detainees from the corrupting influences of jails and prisons. So that leads to less recidivism. And we reduce the risk of jumping bail because we make sure that they attend their court hearings. And finally, we improve public safety by lowering recidivism. Out of the 23 participants, now 24, all of them have been successfully reintegrated, and no one thus far, after already around 5 months, had gone back to prisons. And finally, we help the government save expenses in maintaining these people because of food and other expenses. Right now, we have estimated that we have saved around $2,500 US, okay, since the inception of the program, the amount of money that we have saved with this program. So overall, this is a very small intervention. However, we are confident that this has been gaining grounds and has been replicated in many other communities in the Philippines. And we target that each facility will have this community bailment program that will shield the detainees from further harmful detention. So that's what I report about the Philippines. Thank you very much.
Muchísimas gracias, Raymond, por tu excelente exposición, que ha sido ilustrativa de la situación que se vive también en otros lugares del planeta, muy lejanos a nosotros geográficamente, pero que vemos que lo que ocurre aquí en América Latina o lo que ocurre en Estados Unidos, como contaba April, no es algo propio de esta zona del planeta, sino que ocurre en todos lados. Es decir, las personas pertenecientes a minorías religiosas, étnicas, o los más pobres y con menos educación, es decir, las más vulnerables, son las que tienen una mayor expectativa de ser encarceladas. Son alarmantes no solamente las cifras de sobrepoblación carcelaria en Filipinas que tú nos mostrabas, sino también el alto porcentaje de detenidos, más de la mitad del total, que están en detención por no poder afrontar el pago de la fianza, es decir, por su situación de pobreza. O sea que, al igual que en toda América Latina y en toda América en general, hay un verdadero proceso de encarcelamiento masivo de las personas más pobres. Así que agradecemos mucho tu exposición y ahora vamos a darnos un pequeño momento, un minuto, para mostrar un video que se ha elaborado del caso de Sala Vermelha, del que nos habló Maya. Así que vamos a verlo, es solo un minutito. Gracias.
Aqui dói só, de vez em quando me dá uma dor de cabeça fortona. Forte mesmo, que nem remédio passa. Toda hora eu acordo num susto. Se eu estiver dormindo e escutar um fogo, eu já penso que é tiro. Mas que eu já tô sonhando.
O que a gente quer, só justiça. É só justiça. Porque eles vieram aqui na comunidade, fizeram uma bagunça aqui na comunidade, prenderam um monte de gente inocente.
Então a angústia é terrível, doido que vai acabar logo isso. Não vejo a hora. Ficar tranquilo. Tirar minha habilitação. Arrumar um trabalho e a seguir a vida. Aí eu começar de novo.
Bueno, muchísimas gracias. Realmente, bueno, este es un video más extenso que está disponible para todos ustedes. Maya, no sé si quieres decir algo muy breve respecto de este video, pero en 30 segundos, porque hay mucho público que quiere intervenir. Pero bueno, realmente el video es conmovedor en su totalidad. Son unos cuantos minutos, como 18, si no me equivoco. Pero bueno, ahora vimos un pequeño fragmento. Maya, ¿quieres hacer un pequeño comentario?
I would like maybe, yeah, thank you, Nicholas. I would like maybe just to repeat, it took a lot, right? It took a lot for this young man who already seen the worst of the state to still go on video and continue challenging it. And it's this tenacity of the survivors that they absolutely need. If they give up, we will never see justice. And it's like so unfair that we put it on them, but we kind of have no choice. So again, I would like to call on all of us to remember the role of the survivors that they play in the process and the need for their voice to be heard, which I think in Brazil often they don't even have the last word during the trials. But I think we can discuss.
Bueno, muchísimas gracias, Maya. Y ahora le vamos a pasar la palabra a uno de los participantes de la conferencia que ha hecho un comentario en el chat, pero que le vamos a dar la posibilidad de compartir sus ideas con nosotros. Y se trata de Fabio Amado, que es defensor público y es el coordinador del área de derechos humanos de la Defensoría Pública de Río de Janeiro. Fabio, te damos un minutito para que nos hables un poco de lo que habías expuesto en el chat sobre las cifras de mortalidad en manos de la policía en el estado de Río de Janeiro.
Obrigado, Nicolas. Parabéns a todos os panelistas, obrigado aos organizadores. Aqui no Rio de Janeiro nós vivemos com muita clareza as marcas do racismo em todas as faces do sistema de justiça criminal. A Defensoria Pública recentemente fez uma pesquisa que identificou que 79% das pessoas que são abordadas supostamente que estão sob suspeita da polícia são pessoas negras. Também outra pesquisa que fizemos recentemente demonstrou que 70% das pessoas que são presas ou processadas indevidamente por terem sido reconhecidas por fotografias pelas vítimas e, ao final, são absolvidas, são pessoas negras, ou seja, pessoas que foram identificadas por fotos na fase policial e, em seguida, foram absolvidas, são negras. Então, no caso da Sala Vermelha, nós temos a clareza dessa atuação, nós temos 7 jovens acusados ainda na Justiça Militar por 10 tentativas de homicídio, como contou muito bem a Masha, é fundamental essa construção, essa parceria que se estabelece, e essa parceria com a Open Society e o IBARI permitiram que fosse feito o primeiro protocolo de Istambul no Brasil, e nós crescemos e aprendemos muito, e desejamos estar sempre ao lado da comunidade, da população, fazendo com que a Defensoria Pública esteja nas comunidades, nas favelas, garantindo a amplificação das vozes das vítimas, protegendo e buscando a justiça em todos os setores, em todos os locais possíveis. Muito obrigado.
Muchas gracias a ti, Fabio, por tu intervención y por tu exposición y compartiendo experiencias, en este caso también de Brasil y de Río de Janeiro, que en muchas situaciones son comunes a lo que ocurre en Argentina, en Bolivia, en Perú, en los Estados Unidos. Es decir, hay situaciones que se repiten y la importancia de que las defensorías nos capacitemos, nos formemos, apliquemos instrumentos como el protocolo de Estambul para documentar eficazmente la tortura, el protocolo de Minnesota sobre muertes en contextos de encierro. Todos estos instrumentos son muy importantes para que podamos dar una respuesta eficaz frente a estos hechos y de esta manera lograr prevenirlos o reducir su incidencia. Ahora le voy a pasar la palabra a Nicole Taylor, que es otra participante que se conecta, entiendo que desde los Estados Unidos, y Nicole quería hacer una breve exposición sobre su experiencia en estos temas. Nicole, tienes la palabra.
Yes. Thank you so much, Nicholas. My name is Nicole Taylor. I am a member of the Fellowship Advisory Council at the International Legal Foundation. I want to thank the panel for this inspired discussion of combating systemic racial and ethnic discrimination. I would just like to add to the conversation the importance of addressing racial and ethnic discrimination within institutions like public defender offices, like NGOs, like justice sector entities, which are all really integral to addressing the discrimination that we've heard about and we're seeing in our communities and our justice systems. Really developing clear, concrete frameworks to ensure data-informed change is happening within our organizations and entities is really critical to addressing the issue of discrimination. One way to do this that we found is through action plans, right? These types of plans allow us to move forward the conversation on this issue in a meaningful way. Action plans should be practical, they should be data-driven, in order to really ensure sustainable change, right? So that means identifying key actions, measurable indicators of success, and then from the implementation of those actions and the analysis of that data should be a continuous effort to document the best practices and not just hold that information, but really to incorporate those practices back into new policies aimed at addressing discrimination within our organization over the long term. I think action plans allow us to kind of have a mirror. They serve as a mirror to our organizations and our entities to ask ourselves who we really are on these issues, right? Are we holding space for our team members, our diverse team members, to authentically express their concerns, to authentically contribute to the conversation and to the change? Are we wedded to credentials, right? Or are we committed to a person's strengths? As we heard today, their life experiences, their lived experiences, right? The potential for their leadership and their meaningful contribution to teams. And so it's a mirror for us to ask those questions. And maybe one of the hardest questions to ask is, have we been tolerant? Right? Have we tolerated discrimination within our organization? And what is the plan for eliminating those behaviors? So a data-driven action plan or framework will really allow an organization and entity to meaningfully address aspects of diversity, equity, and inclusion strategies aimed at eliminating discrimination with clear and articulable steps. Leadership engagement is one of those steps, right? Leadership needs to be engaged in order to make sure that this is prioritized. Retention and advancement. I think just as important as who we recruit in is looking at how inclusive and equitable we've been in creating pathways and opportunities for existing, diverse team members to move into leadership positions within our public defender offices and our other justice sector organizations. And then on the issue of recruitment, how are we recruiting, right? Thinking about it, looking at the data, tracking the data, at what levels are we recruiting? It's important to have a lens not just toward diversity, but towards equity and inclusion as well, if we really want to address the issue of discrimination within our organizations. And then finally, my final comments is, and as we can see here, this issue doesn't exist in a vacuum, right? Our day-to-day grind sometimes causes us to be insular, but adding into the action plan concrete ways in which to align and connect with organizations and the external community can really result in sustainable change, not just for our organizations, but for our communities as well. So I just wanted to add a bit on the importance of data and action plans and really creating concrete steps to address discrimination within the organizations that are tasked with addressing discrimination within the justice community. Thank you.
Muchas gracias, Nicole. Gracias a ti por tu muy completa exposición, muy bien condensada en los breves minutos que utilizaste, y la importancia de que las instituciones, las organizaciones, miremos hacia nosotras mismas, hacia adentro, como ahora está haciendo la International Legal Foundation, al revisar sus procesos de designación, de reclutamiento de personal, y también para ver cómo nos acercamos al problema del racismo y la discriminación al interior de la comunidades con las cuales trabajamos, en los países donde estamos presentes. Ahí veíamos que April acordaba y estaba de acuerdo con lo que tú decías respecto de la necesidad de que las organizaciones también miremos dentro nuestro. Así que te agradecemos muchísimo, y ahora le voy a dar la voz y la posibilidad de dar una intervención breve a otra participante de esta conferencia que se ha sumado con su cámara, que es la profesora Verónica Inestrosa. A ver si pueden poner en pantalla a Verónica, que va a hacer una muy breve exposición y comentarios sobre la exposición que había hecho Ana Paula al comienzo. ¿Tenemos a Verónica?
Estoy acá, sí. Pero, al menos en audio. ¿Me escuchan?
Adelante, sí, escuchamos. Sí.
Vale. Bueno, muchísimas gracias por darme la palabra. En efecto, mi nombre es Verónica Inestrosa, me especializo en Derecho Internacional de los Derechos Humanos y tuve a mi cargo el portafolio de el International Bar Association's Human Rights Institute en América Latina, lo cual me llevó a trabajar bastante en Brasil y acompañar el caso Sala Vermelha. Brevemente, quiero reforzar dos puntos y tal vez traer uno más a colación. El primero lo hacía en efecto la señora Oliveira, y es el rol tan importante que juegan los abogados, los defensores, no solo en acompañar desde los primeros momentos de detención, sino en informar, siempre estar informando a la comunidad sobre las cosas que no son normales, que son ilegales y que hemos normalizado, como el racismo en nuestras sociedades. Es injusto que los jóvenes estén esperando que la violencia estatal toque a su puerta, como si fuera una realidad normal. Entonces creo que es importante estar informando constantemente. La segunda, la importancia que informemos nuestro litigio con fuentes objetivas que permitan a los jueces y a los operadores de justicia distanciarse de la discriminación y del racismo con evidencias fuertes y sólidas como son las ciencias forenses. En este caso, en el caso de Sala Vermelha, lo hicimos con el protocolo de Estambul, pero como bien Nicolás decía, también existe, por ejemplo, el protocolo de Minnesota para muertes violentas. Y el tercero es la importancia también de que los abogados nos formemos más en el uso de la fuerza, en los principios del uso de la fuerza, en el tipo de armas letales y no letales y los impactos que estas pueden tener. En el caso Sala Vermelha también se utilizaron balas de goma y otros tipos de armas no letales de forma muy seria. Pero si no nos informamos, si no conocemos esto, nos cuesta preguntar, nos cuesta cuestionar. Entre más informados estemos y más empujemos con nuestro litigio a los jueces a que tomen mejores decisiones, pues más fortalecemos la posibilidad de obtener una justicia sin discriminación. Muchísimas gracias.
Muchas gracias a ti, Verónica. Les pido disculpas que yo corto la cámara, pero los problemas de internet hacen que sea necesario para mantener la buena fluidez de las presentaciones. Yo ahora les voy a dar la posibilidad a nuestros distinguidos panelistas para que puedan hacer una pequeña ronda de reacciones a las cosas que fueron surgiendo durante las intervenciones, que también ustedes hoy son nuestros protagonistas en el panel de hoy, así que les voy a dar la posibilidad de que les habilitemos el micrófono. Voy a ir de manera arbitraria. No sé si April quieres hacer un pequeño comentario de alguna de las cosas que fueron surgiendo. Yo vi que algo habías anotado en el chat, así que cualquiera de ustedes puede venir y hacer una pequeña intervención para ir aproximándonos al cierre del panel. Nos quedan solamente
Sure, Nicholas, this is April. I really just wanted to echo the remarks that Nicole Taylor made from ILF about the importance when we talk about these issues of race and ethnic diversity. It's really important for us to look internally at our own organizations and whether or not we consciously or subconsciously employ white supremacist values. And when I say white supremacist values, I am referring to things that it's not using derogatory names against brown communities, always outward. It shows up based on who we have in leadership, who we value, who we hire, who we promote. And it also shows up in our values and how we work and how we communicate with the people that we serve. Whether or not you see yourself as a person that's saving the communities that you represent, or whether or not you see yourself as a role in empowering communities to save themselves. So I would really recommend to people to really do the internal work of learning about white supremacy and white supremacist values and how they can show up in different ways, and they exist in every organization. So in addition to fighting against the police and other system actors, it's really important for us to start with our own house and clean our own organizations. And that's some very important work that the Black Public Defender Association is doing in the United States within public defender offices, because I know a lot of people who do this work and who have devoted their entire careers to being public defenders. And sometimes it's hard for them to see their own role in upholding systems of white supremacy and oppression, whether it's conscious or unconscious. So I would say start in your own house.
Gracias. Masha?
Sure, thank you, Nicholas. There was something that Nicole reminded me about in a bit different light. I'll come back to the case. You know, I attended one court hearing. I just happened to be in Rio. What shocked me is when the military came in, and there were young Black kids, right? And they asked, actually, the witnesses to take young kids, Black young men, out because they live in the community in the favela nearby and they're afraid of retaliation. No time to comment how serious that statement might have been. So it is about the abuse taking place. We remember that torture is basically like crimes as aggravated assault, right, or homicide, but this happens under the voice of authority. And I know that, for example, in Brazil, there is a position by some of the community organizations that they do not want to go after direct perpetrators because they say it's continued criminalization of Black body. It's with kids that act under orders of somebody else. And to achieve justice, we need to get to somebody else, right? It's really to get to the command and to intellectuals, also for authors of the crime. But yet these acts are horrendous. And we need to challenge them and deal with them. So I think when we look also into like who works there, I believe Nicole also was mentioning, it's not only who works there, but also who holds the power, right? Because I don't believe in the bad apples theory, right? Such a systemic violence happens under the voice of authority. It's not that like I choose to treat somebody badly. And I think it's important for us to also, when we look at the diversity, to see it along the lines of power, both in the institutions that protect rights and institutions that often commit, unfortunately, big human rights violations.
Muchas gracias, Maya, por tu intervención. Ahora le voy a dar a Ana Paula. ¿Quieres decir alguna cosa? Tenemos la posibilidad de escucharte un minutito más, si quieres. Todavía nos quedan unos pocos minutos. Ana Paula, habilita el micrófono, gracias. No estamos pudiendo escucharte, Ana Paula. Disculpas, pero no estamos recibiendo tu voz. A ver si podemos solucionar el problema. Mientras le paso a Raymond, a ver si podemos solucionar el problema con el micrófono de Ana Paula. Raymond, ¿quieres decir algún comentario final? Algunos breves segundos nomás.
Yes. I have two things that I would like to highlight. First is the notion of strategic litigation, where we could highlight some of the key issues experienced by one of our clients and test the system and see whether we could learn something from our experience by making this key litigation. So for example, in the Philippines right now, we have so many issues where people with heart conditions or health conditions stay in jail for very long and undergoing trial. And we have been wanting to have a house arrest where they could be put on house arrest while undergoing trial. But we don't have any enabling legislation to do this. So we are filing a test case to the lower court and determine how the lower court reacts. And if we win this case, this could serve as a precedent for other cases that we handle. So it's a very strategic way. We learn by our experience of challenging the limitations of the system. The other one is the notion that people who have experienced this problem should be the ones also involved. Okay. For example, if you're an African American here in the United States and you're a lawyer, it would be very beneficial if you are organized and engaged, because now you could understand really the situation, fight for them with all your heart, with all your mind, because you understand the experience. And this is what I'm doing in the Philippines as well, because I was once a victim of false accusation. I was put in jail for almost 7 years for a crime I did not commit. I was eventually acquitted. And I told myself, Lord, just release me, and then I'm going to fight for these fellow Filipinos of mine. And that's what I've been doing. And when I tell my stories to other Filipinos who are detained, they believe in me because I was once part of the system, and they trust me, and then we learn together. And that's what I'm doing right now, organize all these previous convicts and previous detainees who underwent wrongful process, and we challenge the systems as well. And it gives credence to our testimonies because we experience it firsthand. And that's the key way to organize, educate, and continually mobilize so that people in the system will be eventually, we call it Janig, they will be moved into action. So that's my two key points: strategic litigation and involving these people who understood the system very well.
Muchas gracias, sin duda, el haber vivido en carne propia las miserias y los horrores de una prisión tan difícil y tan sobrepoblada como Filipinas, te dan un rol privilegiado y más que autorizado para poder luchar y trabajar junto a los afectados por estas violaciones a los derechos humanos. Ahora, Ana Paula, a ver si puedes habilitar el micrófono y podemos escucharte así como has comenzado, que puedas finalizar tú con un minutito. A ver.
Olá, vocês estão me ouvindo? Estão ouvindo? Então, eu queria reforçar um pouco do que a April disse, né? Dessa coisa da gente precisar se enxergar no, né? Então, é um pouco disso, acho que tem que haver uma reforma mesmo, né? Tanto no sistema judiciário, principalmente no sistema judiciário, porque é um local onde a gente chega e a gente é tratado com toda frieza. A gente não consegue também, nem se enxergam na gente, nem a gente consegue ver justiça vindo daquelas pessoas, porque a gente já chega ali sofrendo preconceitos, né? A gente leva os casos dos nossos, um local onde a gente acredita, antes de conhecer, que poderíamos encontrar justiça, e o que a gente encontra é preconceito, racismo, e a gente vê as vítimas sendo julgadas ao invés de quem realmente deveria ser julgado. Então, acho que é mais do que urgente uma reforma no judiciário, principalmente.
Muchísimas gracias, Ana Paula, por tu última intervención. Muy corta, pero muy clara y concreta la idea. Y bueno, creo que ya estamos llegando a los minutos que tenemos para este panel. Yo solamente para hacer un pequeño cierre, me parece que nos quedamos con alguna serie de ideas muy claras, como puntos de acción, pensar hacia futuro, y perdón por la arbitrariedad de solamente escoger 3 o 4, me parece que ha surgido de una coincidencia entre todos nuestros panelistas y los panelistas de hoy acerca de la importancia de que estemos informando constantemente acerca del trabajo que se hace desde los organismos que defendemos derechos humanos, estatales o también organizaciones no gubernamentales, y el contacto y el trabajo conjunto y articulado en alianzas entre cada uno de nosotros para poder tener una presencia más fuerte. Obviamente también la cuestión que surgió sobre el racismo estructural y la importancia de que se le dé voz y pertenencia e integración en los incluso lugares de liderazgo, como bien destacaba Maya, retomando lo que yo había dicho antes, y como había dicho April en su presentación inicial, en los lugares de liderazgo de las asociaciones que luchan para terminar con el racismo y contra la discriminación sistémica. Entonces, me parece que esta es otra idea con la cual no tenemos que quedar, ¿no? La importancia de que se le dé la voz a los afectados, a las víctimas, y Raymond, como un ex privado de libertad, también es una voz de una víctima que se pudo hacer eco de todo lo que sufrió y poder trabajar y luchar junto a los que hoy lo sufren para lograr mejoras en las condiciones de detención y en las condiciones de las prisiones en su continente y en su país puntualmente. Y finalmente, para concluir con lo que dijo Ana Paula y que estuvo sobrevolando todas las intervenciones, la relevancia y la importancia de que la justicia finalmente sea una reforma verdadera, una reforma estructural, una reforma que abandone los prejuicios discriminatorios y deje de destratar, deje de maltratar a las víctimas cuando acuden a su servicio en ayuda, porque no tenemos nunca que olvidarnos que el servicio que prestamos los defensores públicos y que prestan los jueces, los fiscales, es un servicio público, y nos debemos al público, y eso es lo que justifica que nosotros trabajemos en esto, que el Estado nos pague por esto, darle un servicio a la ciudadanía, y esto tiene que significar poner fin a esos prejuicios y a esas instancias de discriminación a las que muchos se ven sometidos, y lo hemos visto muy claramente con el testimonio, por ejemplo, de Ana Paula en el día de hoy. Así que yo les quiero agradecer a los panelistas principalmente, también a todo el público que nos estuvo acompañando de distintos lugares del planeta en la mañana o en la tarde de hoy. Realmente ha sido un debate muy fructífero y vamos a tratar de volcar estas conclusiones y los puntos más importantes, incluso algunos que no he mencionado ahora, en el documento final que se va a aprobar el día de mañana, a lo cual los invito. Mañana, en el día de cierre de esta conferencia, vamos a tener exposiciones magistrales muy importantes, y vamos también a hablar de la Constitución, en realidad del refuerzo de una ya constituida red internacional de proveedores de asistencia jurídica, y bueno, vamos a escuchar las palabras de distinguidos expositores a las 10 de la mañana, hora de Brasil, 9 de la mañana, hora del este de Estados Unidos. Los esperamos aquí en este webinario para el cierre, y les agradezco nuevamente la presencia a todos los expositores y también a los disertantes. Muchas gracias y buenos días.